Hello and good afternoon, and thank you all for joining us for this first webinar in a five-part series on employment compliance in government contracting. Today's program focuses on compliance basics, and will also provide an outlook on DOL enforcement. My name is Matt Kissling. I'm an associate in Thompson Hine's Labor and Employment and Government Contracts Practice Groups. I'm based in Cleveland, Ohio. And I primarily focus my practice on advising government contractors and subcontractors on all aspects of their employment-related obligations under federal, state, and local laws and regulations. I'm also joined today by Ray McCann, who is a senior counsel in Thompson Hine's Government Contracts Practice Group based in Washington, D.C. And prior to joining Thompson Hine, Ray served for over 26 years as general counsel, secretary, and vice president for multiple telecommunications and high technology companies located in the United States, Australia, and in the United Kingdom. So today's webinar will outline the basics of what a current or prospective government contractor or subcontractor needs to know with respect to employment compliance and potential monitoring from the federal government. Our discussion will include an analysis of the Department of Labor's current enforcement efforts, as well as a forecast of what we can expect from that agency in the near future, especially in 2019. Before we begin, I just have a few preliminary notes about the materials and the technology that we're using today. Today's program is being recorded and will be available on our website. Questions will also be addressed at the end of the program, and you should all have a little dialog box on your screens. So can you please submit any questions using the question box on your side panel. Our presenters today will also try to address all questions, but given time constraints, we may not have time to get to each and every one of them. If we're not able to address your question during the presentation, we will make sure to follow up with you directly and answer any additional questions you might have. So since we are lawyers here, we always like to have just a quick disclaimer about our presentation. And so just to know that the presentation today is intended to provide you with an educational information about certain legal matters of interest, and we hope that you find everything enjoyable and informational. The presentation is not intended as legal advice, and it does not establish an attorney-client privilege with Thompson Hine. For this reason, we recommend you should not act upon any information contained in the presentation without first consulting a legal counsel, whether it's with us or with another organization. With that said, today we're going to be covering three main topics. The first of which is who exactly is required to comply with the various employment requirements in government contracting, specifically addressed what it means to have a covered contract or subcontract. Then we're going to jump into a discussion of the essential compliance requirements from an employment perspective, specifically affirmative action, equal opportunity, and then also a brief discussion on certain wage and benefit requirements depending on the kind of contract that you might have. And then finally, we're going to talk about why is compliance critical for your business. And this is going to involve an overview of current government enforcement activity from both the Department of Labor as well as the contracting agencies themselves. And then we'll transition into and finish up with a discussion of the potential consequences of noncompliance. So from a starting point, these regulatory employment compliance requirements generally apply to any organization that qualifies as a government contractor or a government subcontractor. Both of these terms tend to be specifically defined in the various regulations that the Department of Labor enforces. And the Department of Labor considers a government contractor to be any entity that's part of an agreement with a department or agency of the federal government for the purchase, sale, or use of goods or services. So that last part identifies a number of different contracts that may bring you within the compliance obligations. Starting with the supply contract, this is an agreement where you provide products to a government agency, such as to GSA or to a military base. And then another type of contract is a service contract, where you're agreeing to provide services to a government agency through the use of service workers. And the meaning of being a prime contractor is where you actually hold a contract directly with a particular government agency. Now, the bit more confusing and gray term is what exactly is a government subcontractor? And this is really what brings a lot of companies within the employment compliance requirements in the jurisdiction of the Department of Labor. And so a government subcontractor is defined to be any organization that is essentially part of any agreement with a prime government contractor or a higher tiered subcontractor to either furnish supplies or services that are necessary to the performance of the government contract, or to perform, undertake, or assume any portion of a federal contractor's obligation under that prime federal contract. The important thing to remember here is that these compliance requirements can extend to any subcontractor in a chain leading to the final product or service that is provided to the government. Specifically, these compliance requirements can extend down to lower tiered subcontractors to what we say is the nth degree. So obviously that's a lot of words and language to think through. I always find it helpful to look at a diagram.
Matt, before we go there, I should note that the definition of subcontractor in FAR 44.101 is a little bit different than what is in the DOL regulations. And I think that it's important to for the participants to try to determine whether or not they are in fact a subcontractor. Also, the DFARS has a proposed change to the definition of a subcontractor to exclude commodities where the purpose of the agreement is to exclude flowdowns in the supplier agreement that's not identifiable with a particular prime contract. And generally, if we can argue that an agreement with another contractor is outside the definition of a subcontract, generally you're going to be better off. And if you can meet the exclusion, the proposed exclusion in the DFARS, or can avoid, I guess, the application of the definition in 44.101, then you might have an argument that you would also be outside the definition in the DOL regs.
That's a very good point, Ray. I think that is something that, any organization where if you're unsure as to whether you would fall within the definition of a government subcontract, that's certainly a worthwhile assessment and analysis to undertake. From the Department of Labor's perspective, I will say that they tend to take a very expansive view as to who can be covered by these regulations, whether it's as a direct government contractor or from a subcontractor perspective. And I think this diagram we have here is a pretty good example of that. So here you have the federal government, pick your agency, and we have a prime contractor who has agreed to supply the government with box trucks. So the prime contractor, in order to put those, assemble those box trucks, farms out a number of the components to other companies. So here you have subcontractors 1, 2, and 3. Subcontractor 1 provides the fabricated metal sheets that would, go into the outer shell of the truck itself. Subcontractor 2 provides the dashboards that go into the trucks, and subcontractor 3 provides the radio equipment that goes into the box truck. Now, subcontractor 2, obviously dashboards are made of a number of different materials, and so instead of doing all that themselves, subcontractor 2 receives resin compounds from subcontractor A, and then the screws and the widgets from subcontractor B that then are used to put together the dashboard. So in this situation, it's pretty clear that subcontractors 1, 2, and 3 are all going to be covered government subcontractors because they're providing a big component of what ultimately goes to the product that is sold to the government. But with that said, subcontractors A and B in the situation would also be covered because they're providing an essential component that goes into the dashboard that then is sold to the contractor that ultimately goes into the end product to the government. So in both situations, the resin compounds and the screws or widgets would be materials that are considered necessary to the performance of the ultimate government contract, here assembling and providing the box truck to the federal government. And so for this reason, subcontractors A and B would both be considered covered subcontractors and would be expected to comply with the various employment requirements that apply to government contractors as a whole. So unfortunately, the analysis really does not end with just subcontractors. Another thing to consider is that these requirements can also will apply to every one of your businesses, business units, divisions, or physical locations if you are found to be a government contractor or a subcontractor. And the important thing to remember is that it even applies to any businesses or locations that do not do any sort of government-related work. So a good example would be, let's say you have 50 locations spread out across the United States, and you only have one of those physical locations, let's say in the state of Ohio, that actually does business with the government. From an employment compliance perspective, you're not only going to be expected to comply for that one facility, but also the 49 other locations that you have, even though those other places do not do any government-related work. A similar situation applies if your organization is in a parent or a subsidiary or an affiliated company relationship with another organization. The compliance requirements can also be extended to those other companies if they constitute what the Department of Labor calls a single entity. And what this really looks at is there common ownership? Do you have common directors and officers? Is there a common exercise of control? And the most important factor, is there a unity of personnel processes or central personnel processes that apply across the board to all the organizations? So some of the questions to ask there are, do you have shared services for human resources? Does one organization have control over filing EEO-1 reports? Do you have a central employee handbook that applies to each and every organization? If the answer to those questions is yes, then the Department of Labor, when they take a look at your situation and conduct this single entity test, they're going to find that all those different entities are essentially a single entity and will all be covered and expected to comply with employment compliance for government contractors. So here's another good kind of diagram example, is where you have two subsidiaries, both of which are 100% owned by the parent company. Now, subsidiary 1 is the entity that holds a government contract. Subsidiary 2 has nothing to do with that government work. Now, in a normal situation, you would not expect subsidiary 2 to be covered by the various employment requirements that are enforced by the Department of Labor. But let's assume, for the sake of argument, that the parent provides HR, financial, and legal shared services to both subsidiaries, and also has the central control over preparing and filing EEO-1 reports for all entities. These additional facts would most likely be the tipping point that would then make subsidiary 2 also covered as a government contractor, and therefore expected to comply with the various requirements, even though they don't do any sort of government-related work. So you may be asking yourself, what are some ways how can I tell if I may be considered a covered government contractor? One easy way from the outset is look at the language of your contracts. Do your contracts have any of these clauses in here, what we call the FAR clauses? Do you have anything that mentions affirmative action compliance or equal opportunity or service contract labor standards? If the answer to that question is yes, there's a good chance that either the government or the other organization that you're doing business with considers you to be covered as a government contractor or subcontractor, and therefore you would be expected to comply with the various employment-related compliance issues. Another thing to look at is, do any of your contracts have something like an EEO clause like we have here, where this is essentially a flow-down incorporation by reference clause that you tend to see in subcontracts related to government-related work. Again, if this clause is included in any of your agreements, that's a pretty good initial indicator that you may be covered and that you would be expected to comply. So if the answer to that question is yes, what are the essential employment-related compliance requirements that you need to worry about? We always like to call them the big three, and that's where contractors are covered by a variety of different affirmative action and equal opportunity requirements under initially Executive Order 11246, which is really it's the original affirmative action legal requirement that was passed in 1965, a year after Title VII of the Civil Rights Act came into being. And this Executive Order 11246 requires affirmative action in employment compliance for minorities of females, and it applies to if you have total contracts or subcontracts of at least $10,000 in value. The second law is the Vietnam Era Veterans Rehabilitation, Adjustment, and Assistance Act. That's a mouthful, so we just call it VEVRA. And this applies if you have a single government contract or subcontract of at least $100,000 in value. And then the third big law is Section 503 of the Rehabilitation Act, which applies for individuals with disabilities. And this comes into play if you have a single contract that's at least $10,000 in value. So under the executive order, overall, this prohibits employment discrimination based on a variety of traditional categories, including race, color, religion, sex, and national origin. And then more recently, they've added sexual orientation and gender identity. So if you're covered by the executive order, your equal opportunity requirements are actually broader than what would otherwise be required by Title VII or by a lot of state laws, because it specifically includes sexual orientation and gender identity as protected classes. The executive order also requires affirmative action to promote hiring and retention of minorities and females in employment. And if covered, you're actually specifically required to include the executive order's pretty lengthy EEO clause in any subcontractor purchase order that you enter into with another organization. At the end of the day, the important thing to remember is that you are responsible for the flow down of the executive order's requirements to your own subcontractors or vendors. So even if you are simply a subcontractor somewhere in the chain, if you then send out work to another organization in connection with the ultimate government contract, you're going to be expected to make sure that the executive order's requirements flow down to those other companies, and to a certain degree, you may be held responsible for their compliance with employment-related requirements. Under Section 503, this, as mentioned before, prohibits employment discrimination against qualified individuals with disabilities. So Section 503 is essentially a supplement to the Americans with Disabilities Act, and is specifically targeted to apply to organizations that do government-related work. Obviously, as a private employer, you're still going to be covered by Americans with Disabilities Act, as well as any state or local disability discrimination laws. So Section 503 adds additional components to your compliance requirements in this area. And like the executive order, Section 503 requires affirmative action for the hiring and retention of individuals with disabilities. And the thing to note here is a lot of Section 503's teeth are contained in their implementing regulations at 41 CFR Part 60-741, which was overhauled in March of 2014 and now imposes a significantly expanded degree of affirmative action requirements, which we'll touch on in a few minutes. And then finally, under VEVRA, this prohibits employment discrimination against protected veterans. Now, protected veterans is a very specifically defined category. It includes 4 types of veterans. First, active duty wartime or campaign badge veterans. So if you have employees who served in Iraq or Afghanistan, they would most likely fall within that category. You have armed forces service medal veterans. So individuals who served in the military may not have gone overseas, but received some sort of a medal in recognition of their service. Disabled veterans. So these are veterans who became disabled through their military service. And then recently separated veterans. This is one of the catch-alls, and really applies to anyone who comes to work for you who served in the military at some point within the past 3 years before their hire date. obviously a recently separated veteran, once they get outside that 3-year window, they may fall within one of the other 3 categories of protected veterans. But generally speaking, anyone who's fresh out of the military service, they come to work from you, they're going to fall within that recently separated veterans category. And like Section 503 and the executive order, VEBRA requires affirmative action for hiring or retention of qualified protected veterans. And similar to Section 503, VEBRA's teeth are in their regulations, which were similarly overhauled in March 2014 and impose again, an expanded degree of affirmative action obligations. So with all that said, what are essentially the compliance basics that we always look at when doing business with the government? Again, it starts with incorporating your EEO clauses into contracts. As I mentioned before, you are responsible and need to include these clauses in any subcontracts or purchase orders that you send out to other organizations. At a minimum, you can incorporate the clauses by reference using language similar to what we saw a few slides ago, where it makes reference to the various regulations and specifically incorporates them into your contract. You're also responsible for updating your EEO policy documents, whether these are standalone policies or contained in an employee handbook. And you need to do this to include sexual orientation, gender identity, disability, and protected veteran status. And one thing that I don't have on the slides, but I think is worthwhile mentioning, is the protections for sexual orientation and gender identity actually apply to your health insurance plans as well, where the Department of Labor takes the stance that under the executive order, discriminating against individuals based on gender identity or sexual orientation in the provision of health benefits will violate the executive order. And this applies even to, as the Department of Labor says, any sort of exclusions of coverage for care related to gender identity, whether it's gender dysphoria or gender transition. A categorical exclusion of coverage for those types of medical services on its face will be found by the Department of Labor to violate the executive order. So that's can be a bit of a headache, and it is an issue we've been seeing as companies engaging in government work are trying to balance your obligations under their health insurance plan without running afoul of the executive order's requirements. On top of updating those documents, you're also responsible for a number of different workplace postings, such as the EEOs, the law poster, and the supplement, a pay transparency, non-discrimination poster. This is something that the OFCCP, the Department of Labor, rolled out a couple of years ago. Similar to notice of employee rights under the federal labor laws. And generally speaking, these posters need to be placed prominently at each of your locations where everyone can see them. And additional policies, including the pay transparency policy, actually need to be incorporated into your employee handbook as well, which is then distributed to employees. Another compliance basic is the filing of EEO-1 reports, and more importantly, the VETS 4212 reports. Generally speaking, as a private employer, most of you are probably already required to file EEO-1 reports. As a friendly reminder that the current deadline is May 31st of this year. That was extended by the EEOC back in February due to the government shutdown. I'll have more to say about the EEO-1 a little bit later. And then the VETS 4212 report, this is reporting your current demographics of veterans at each of your locations. And this is something that specifically applies to government contractors. The deadline for the VETS report is September 30th of 2019. Another requirement is, related to job postings and taglines, where any job advertisement or job posting that you have, whether it's in paper form, in a newspaper, or on your careers page, does need to have, at a minimum, a tagline identifying your status as an equal opportunity affirmative action employer. And the tagline we have listed here is what the Department of Labor considers to be the minimum requirement to include in your job postings and your advertisements. And you're also required to post any available jobs with your state or local employment services agencies. And those relevant agencies differ depending on which facility you're talking about. So it's something you need to look at on a company-wide basis for each of your individual locations. Are we posting with the necessary state or local agencies? And then a big requirement from a compliance perspective is record keeping. As government contractors are required to maintain all relevant employment-related records for either a 2 to 3 year period, depending on the types of records at issue. Generally speaking, personnel files, applicant hire records, affirmative action plans, stuff like that need to be kept for at least 2 years. And then 3 years generally applies to self-identification forms for disability status or veteran status, as well as certain data related to veteran and disabled job applicants and hires that is collected on an annual basis. The thing I'll note here is that these record keeping requirements are in addition to any state record keeping that you may have to follow for workers' comp, unemployment, stuff like that, as well as other record keeping requirements under the FAR regulations that apply to government contracts in general. I believe, Ray, you have a comment on those other requirements.
Yeah, I just wanted to mention that the requirements here actually are shorter than the FAR requirement. If you have FAR 52215-2, the audits and records clause in your contract, then the records retention policies and the time limits in FAR subpart 4.7 apply, and specifically FAR 4.705-2 deals with pay records, and the requirement there is 4 years after final payment of the contract. Normally, most records under the FAR retention policy are 3 years after final payment, but for pay records, it's 4 years. You may actually have in a special contract clause, in fact, I've run across record retention requirements as long as 10 years after final payment. So it's in addition to the DOL and state law requirements that Matt mentioned, you'd have to comply with all of them, unfortunately.
So I think from just an overall perspective, good practices perspective, this is a situation where it may not be a bad idea to consider adopting a pretty thorough document retention policy for your organization, where it lays out the specific types of records that you're talking about and what the related retention requirement would be. That way you have essentially a chart or a laundry list of the various types of records that you're expected to maintain, and your personnel know how long those records need to be kept in your files. So what's the one thing I haven't mentioned yet? That's affirmative action plans. This is probably one of the most burdensome annual employment requirement of doing business with the government. And just from a summary level, a written affirmative action plan is required for each of your business units, divisions, and facilities, as long as you have a single government contract or subcontract that's at least either $50,000 in value. So that would require an affirmative action plan for minorities, females, individuals with disabilities. Or you have a contract that's at least $150,000. That's where a protected veteran affirmative action plan is required. Any location with at least 50 employees must have its own affirmative action plan. If you have locations with less than 50, you can give it its own AAP, and in certain circumstances, you can either roll it into your headquarters affirmative action plan, or it can be included in another geographic location's affirmative action plan. I include asterisks there because there are limited situations where that can occur, and it generally involves some sort of central reporting of individuals at a location to another location. So if you have a facility manager who's in charge of a plant with, let's say, 35 employees, if that person's supervisor sits, or manager or director sits at your corporate headquarters, because the plant manager reports up to corporate, you could then roll that 35-person facility into a headquarters plan for compliance purposes. On the flip side, let's say you have two facilities right down the road from each other in California. One has 60 employees, the other one has 35, and let's say they share a common human resources representative who sits at the 60-person facility. In that situation, you would be permitted to roll the 35-person location into that larger facility and have essentially a consolidated affirmative action plan. One of the potential risk areas there, you could come in what we'll talk about in a little bit during a compliance audit from the Department of Labor, where if you still have a consolidated plan, the DOL might look at that and decide to audit more than one facility at the same time, as opposed to focusing their efforts only on that 35-person facility. So if you get an audit, a good practice would be to essentially separate out that 35-person location for purposes of the audit and keep them separated for at least a 2-year period. And then at the end of that period, you could then consider rolling them back into either the headquarters or the larger location's affirmative action plan. So what are some of the nuts and bolts of having an effective affirmative action plan? It really starts with the self-identification inquiries. So as a government contractor, you are required to voluntarily invite employees to identify certain demographic information. Traditionally, it was gender and race or ethnicity, and this is the same data that you would use to put together your EEO1 reports. It's the EEO1 categories, such as Hispanic or Latino, Caucasian, or other minority categories. One of the newer requirements under VEBRA is self-identifying for protected veteran status. Important thing to remember is you're required to do this at both a pre-offer and a post-offer level. So if you have an applicant, when they submit their materials on your website, you should be inviting them to complete a self-identification form for veteran status at that point. And then when you get through the application process and you decide to extend them an offer, once you extend the offer, then you need to provide them a second opportunity to identify at some point between the date when you extend the offer and their onboarding or start date with your company. Similar requirements apply to disability status. Again, you have to do it at both pre-offer and post-offer. And on top of that, you're actually also required to survey your current workforce at each location at least once every 5 years. And during that 5-year period, you're also required to remind your employees that they can update their disability status at any time. So there's a lot, much more burdensome requirements for disability self-identification. And the government has been very strict about these types of inquiries, where they actually require you to use a specific government form, the CC-305, without any sort of alteration. The government says you can use an electronic version, but it essentially needs to mirror what the paper form says in appearance and when you post it on your website. So there are some opportunities to go electronic with it, but it does need to mirror the paper form. So once you get your self-identification data into place, some other components are an AAP needs to have both a job group and an organizational profile. So the job group, they essentially outline the demographics of your workforce as of what we call a snapshot date and time. Traditionally, we always see December 31st as kind of that snapshot date of time. So let's say for a 2019 affirmative action plan, your snapshot date would be December 31st of 2018. So it's looking at your workforce as of the end of the prior calendar year. And what these organizational and job group profiles do is they really just break down your counts of race and gender classes by EEO1 job groups and internal organizational structures, whether it's a job family or departments or something similar to that. Another component is you have to look at underutilizations and placement goals for the year. And what this does, it analyzes the percentage of females and minorities in your workforce versus what the expected availability would be based on statistical data. So whenever we prepare these affirmative action plans for clients, we pull out statistical data from the last census, so the 2010 census, because that's, at this point is still the only truly reliable form of demographic information that you can use to run these statistical analyses. Obviously, the 2010 census is a bit dated, but the government still considers that to be the most accurate predictor of availability for your workforce. And if you have an underutilization in a particular job group, then that will establish a placement goal, which essentially equals the percentage of the expected availability for either females or a certain minority class in that job group. So a good illustrative example is here. Let's say you have a plan for a facility with 150 employees, and that plan demonstrates that the technician's job group was comprised of 10% females, or 5 out of 50, as of December 31st, 2018. Now, when you run the analysis in your plan, it shows that the expected female availability for technicians is 35% based on the census data that you use. And for this reason, the analysis will show an underutilization for females in that job group because your actual makeup is 10%, but the expected makeup is 35%. Now, if that difference is found to be what we call statistically significant, then that would trigger affirmative action obligation for you to try and correct the placement goal. Now, the government considers 2 standard deviations to be statistically significant. And when we run the analysis, for clients in our software, it automatically calculates whether or not a difference like this would reach that 2 standard deviation limit. If it does, it then sets a placement goal, which here would be equal to 35% for females. So at the end of the day, you'll have a 35% placement goal for females in the technician's job group for the current affirmative action plan year. So currently 2019. So on top of these placement goals and underutilization goals, some of the newer Section 503 and VEVA requirements is you actually have specific hiring benchmarks and utilization goals for individuals with disabilities and protected veterans. So Section 503 requires a 7% utilization goal in each of your job groups for individuals with disabilities. And then VEVA requires an annual hiring benchmark for protected veterans for an entire facility equal to a certain percentage. So for current year affirmative action plans, it's 6.4%. The other day, the Department of Labor issued the new benchmark percentage, which will be 5.9%, and that'll take effect March 31st of 2019. Now, the important thing to remember is that you have to apply the benchmark that's in effect as of the start date of your affirmative action plan year. So if your affirmative action plan year starts on January 1st of 2019, you're still going to need to use that 6.4% hiring benchmark for veterans. And then for next year's plan, you'll be able to drop down to 5.9%. What we've seen historically is that the annual hiring benchmark, it has been dropping since it was put into place back in 2014 because it's based on what the current population of available protected veterans is in the civilian workforce in the United States. So that's up until March 30th, it's 6.4%, then that'll drop down to 5.9. Another fun requirement that you have is you actually have to conduct annual data collection for veteran and disability applicants, where you collect the total number of applicants who identify as either a veteran or disabled, your total number of job openings and jobs filled, your total number of hires, and your total number of hires who identify as disabled or protected veteran. And this is data that you do need to maintain for a 3-year period. And in the event you get audited by the government, it is stuff that they're going to be asking for the prior year. Outside of these numbers, some of the other basic components you are required to put into place outreach and recruitment efforts and document those efforts, where essentially you're taking steps for the outreach and recruitment of all the protected classes, especially those that may show an underutilization in your affirmative action plan. This also involves a periodic schedule for reviewing your job descriptions or your job postings or other forms of external engagement with organizations that may cater to a particular protected class. And the important thing here is to document and annually assess the effectiveness of your outreach efforts. And you can do that through an internal audit and reporting system. But it's a formal process for conducting those annual effectiveness assessments of your efforts, as well as the progress you're making on any goals or benchmarks that you might have. And included in this is annually tracking all of your employment activity, such as hires, terminations, and promotions at a particular location, and running analyses to make sure that there are no protected classes being adversely impacted by a particular employment decision. And if there is an adverse impact, getting to the root and figuring out why or what is going on there and why that problem may exist. And again, when you look at all of your efforts, if efforts are not being effective, so if you still have persistent placement goals or underutilizations, then what you need to do is reassess your efforts and identify new objectives or strategies for meeting your goals. I mentioned before that I was going to be talking a little bit more about the EEO1 reports. So this is a relatively new development where, if you remember from a couple years ago, the EEOC under the Obama administration came out with this idea about an EEO1 summary pay report, which would require contractors and subcontractors to report summary pay data and aggregate hours work data as part of their annual EEO1 filing requirements. And what it does, it requires you to have both pay and hours work data reported within each EEO1 job group and then broken down by 12 specific salary bands. Now, when the new administration came in to office, they pretty quickly put a halt to this summary pay report requirement. But conveniently, DC federal court on March 4th actually issued a decision saying OMB got it wrong, and they essentially did not have the authority to put a halt to these EEO1, these pay summary reports. And so they were actually reinstated by the DC federal court, and the court is requiring the EEOC to submit essentially an action plan or status update as to how they're going to roll out the pay summary reports. I believe that report is due sometime early next week. And at this point, it's unclear as to whether these pay reports will apply to the EEO1 report that you need to file by May 31st of this year. There are a couple things that could happen. They could wait to implement it until next year's plan, or they could further extend the EEO1 filer requirements for this year. With that said, there's a pretty good chance this court's decision is going to get appealed. So it's certainly, still up in the air whether or not these summary pay reports are actually going to come into being. But it is something to keep in mind as we move forward. And here's what a potential sample report would look like if we, at the end of the day, have to move forward with filing this stuff with the government. And then just some additional requirements, from a wage and hour perspective. If you have a service contract with the government, if you supply products to the government, you're off the hook here. But if you have a service contract with the government, you do have specific prevailing wage and fringe benefit requirements under the Service Contract Act. And it requires, for any employee who works on the service contract, they must be paid a specific prevailing wage that's set forth in a wage determination issued by DOL. And you also have to provide them specific fringe benefits. And this includes annual paid vacation, at least 2 weeks per year, paid holidays, and then certain health and welfare benefits to employees, or pay a cash equivalent instead of giving those benefits. And then new as of 2017 is paid sick leave. If you have a service contract that you signed on or after January 1 of 2017, you're required to provide up to 56 hours of paid sick leave per year. And these requirements do have some specific carryover requirements for any unused leave that an employee has at the end of the calendar year. So, and I believe the third or fourth installment of this webinar series, we are going to be going much more in depth into the specifics and the nuts and bolts of Service Contract Act compliance. But for our purposes here today, this is just a good initial outline of some of the things you need to think about if you're interested in having a service contract with the government, or you may be a subcontractor under a service contract. So obviously that, decent number of compliance requirements from an employment perspective that we need to think about here. So, the next question we might be asking ourselves is, why is compliance critical to your business? And this is really where we're going to talk about what the government's currently doing to enforce these requirements and making sure contractors are doing what they need to do. And, the government really has a number of different sources that they can use to enforce it. One option is through the contracting agency itself, so the organization that actually issues the prime contract to a company, and then obviously the U.S. Department of Labor, specifically its OFCCP and wage and hour divisions. So Ray is going to really tackle and talk to you about what contracting agencies are currently doing to enforce all these requirements.
Okay, thanks, Matt. So there's, as you can see on this slide, there are 4 general types of remedies available to the government in addition to the Department of Labor remedies that Matt's going to discuss later. So we're going to talk about contract remedies, administrative remedies, civil remedies, and criminal remedies. And as we discuss these, keep in mind that generally the contracting agency has the lead for contract and administrative remedies, while the Department of Justice has the lead for what we call the civil and criminal remedies. And also keep in mind that as we talk about these, the government puts a strategy together for how they're going to pursue remedies. And it varies on a case-by-case, fact-specific basis. The government usually tries to coordinate these so that pursuing one remedy does not adversely affect their ability to pursue other remedies for things like statute of limitations and discovery purposes. So this next slide shows the contract remedies that are typically available and used by the government contracting agency. Of course, we start with the termination for default. This is for a material breach of any contract clause, including the applicable FAR labor clauses. They can also void or rescind a contract. Typically, you would see this in the case of a misrepresentation affecting the contract award. Denial of claims, although the Department of Labor has the jurisdiction on deciding what wage determination applies and how much an employee may have been underpaid, for example. There are disputes regarding who should pay the back wages, whether that's on the government or the contractor, and the boards of contract appeals and Court of Federal Claims do have jurisdiction to determine, based on the contract language, who should pay. You also see this in the context of costs related to an investigation or legal proceedings under the cost principle, FAR 31.205-47. I think it's a good thing to look at to decide whether or not your costs are going to be allowable or not allowable, and it really depends on the outcome of the investigation or the proceedings. Withholding of payments, typically this is as directed by the Department of Labor or in the contracting officer's discretion for the payment of back wages directly to employees. Liquidated damages, there are clauses, a specific clause under the Contract Work Hours and Safety Standards Act allows for liquidated damages for overtime compensation in the amount of $25 per day per employee. So you have to watch out for that. There may be other contract clauses as well. Suspension of progress payments. This is again to facilitate direct payments to employees. Sometimes the contracting officer decides that that's necessary. We do see deductions for deficiencies in contract performance if it's related to miscategorization of the labor hours applied to a particular task. The contracting officer can take a deduction that's tied to a particular contract specification or requirement. And then finally, non-responsibility determinations. This is a big deal because it can affect future contract awards or future orders or contract extensions. Before we talk about the other types of remedies, I just wanted to mention this FAR clause 52203-13, Contractor Code of Business Ethics and Conduct, because if this is in your contract and it's a required clause in all contracts greater than 5.5 million with a performance period greater than 100 days, the contractor's compliance or non-compliance with the clause could impact the government's strategy for applying the other non-contract remedies that I'm going to discuss. And basically, the clause, we're not going to go into its detail here, but it requires the mandatory disclosure of credible evidence of violations of certain criminal laws, the Civil False Claims Act, as well as significant overpayments under the contract. And penalties for non-compliance can include suspension or debarment for a knowing failure to timely disclose such credible evidence. And so that leads into the next slide, our second type of remedies available to the government, called administrative remedies. These are dealt with in FAR subpart 9.4, and primarily we're talking suspension or debarment, suspension being a temporary disqualification from contracting with the government, while a debarment is an exclusion for a specified period, usually 3 years. Both are used to effectuate the government's policy of only contracting with what's called responsible contractors. And generally, that's a contractor has to have a satisfactory record of integrity and business ethics, including satisfactory compliance with all laws, including the labor laws. The causes for suspension debarment generally, they're a lot more extensively described in subpart 9.4, but it's generally for commission of fraud or criminal offense in connection with a government contract or subcontract. And it's colloquially referred to as the death penalty for government contractors because of its government-wide effect. It's not just the contract with a specific agency that you have the issue with, but it applies government-wide. No new contracts, no orders, no option extensions, and so forth. It's not going to affect, generally, contracts that are in performance are not going to be affected, but no new contracts and no new orders. And it can also impact a company's ability to get state and local procurement contracts. It can affect security clearances, export licenses, and in some cases even commercial contracting. Keep in mind that this is not just at the prime contract level, but also at subcontractor level, and it applies to individuals as well. And in our experience, it's even applied more harshly to individuals and subcontractors, often because they're smaller and they can't fight it as well, or the impact of a suspension or debarment is not going to be as severe on the government. The third type of remedies available to the government are civil remedies under the Civil False Claims Act. This is for knowingly presenting a false or fraudulent claim for payment, or it could be for using a false record or statement to conceal, avoid, or decrease an obligation to pay. They're trying to, for example, hide their labor violations. We see this a lot in misrepresentations and certifications of compliance, either at the outset of the contract award or in conjunction with the submission of invoices. And it is a favorite remedy of the government as compared to criminal remedies because of the evidentiary standard is not quite as high. If you're found in violation of the False Claims Act, the government is entitled to treble damages. That's 3 times their actual damages, and that can be a huge number. But there are arguments that we can make to reduce that number. So basically, that there's no actual harm to the government, just the employees. And I would. If you're interested in looking at this, there's a great Sixth Circuit case, USX Rel Wall versus Circle C Construction LLC. It's at 813 F 3rd 616. And in that case, an electrical subcontractor underpaid its employees by $9,916. The government tried to seek damages for all of the work done by the electrical subcontractor, which amounted to about $259,000. Treble that was $778,000, but the court found that the actual harm was not for the entire electrical subcontractor's work, but instead just for the $9,916 of underpayment of Davis-Bacon Act wages. So just keep that in mind, that they're really looking at there's ways to reduce, I guess, the actual damages. Contrast that, however, is with regard to civil penalties under the False Claims Act. The numbers were actually raised last year by DOJ to the numbers you see on the screen, 11,181 to 22,363 per claim. And since these are penalties, fines or penalties are unallowable under the cost principles FAR 31.205-15A. So this can be a real big number. Don't forget, obviously, the False Claims Act has keep tam provisions which allow individuals to file as like private attorney generals. They can file False Claims Act actions on the behalf of the government, and if successful, they can share in the recovery, typically in the 15 to 25% range. And in the labor area, disgruntled or fired employees often are the original source of a claim for labor violations, and they do have whistleblower protections for reporting. The last or fourth type of remedies is criminal remedies. I've listed three that you're most likely to see in the labor violations context: conspiracy, False Claims Act, the Criminal False Claims Act, which is a need. There's a need for an intent to defraud there, and then the False Statements Act. This is interesting because it is very broad. It applies for knowingly and willfully making a false statement concerning a matter within the jurisdiction of any department or agency of the U.S. government. So misrepresentations, false certifications of compliance can be a violation. It can be, it doesn't have to be made directly to the government. It can be a subcontractor making a statement to a prime contractor. Sworn or unsworn statements, oral or written statements, they all apply. And so time cards, for example, would fall under this. Potential penalties can be pretty severe, monetary and possible jail time up to like 5 years for individuals. So those are the contract remedies. Turn it back to you, Matt.
Yep. So let's talk about quickly about our friends over at the Department of Labor. I know we're pushing up on the 1 o'clock time. I do apologize. We may just go a few minutes over, but I certainly want to highlight for you, all the wonderful things that the Department of Labor can do to you when they're enforcing the employment compliance requirements. So obviously, contractors and subcontractors are subject to random compliance evaluations from the OFCCP. Now, the OFCCP claims that they have a neutral, I put in quotation marks, a neutral selection system for choosing companies and establishments for evaluation, where the OFCCP states that they target companies based on the number of contracts, their EEO1 or VETS 4212 reports, and other census or employee data that comes across their doorstep. From a current enforcement perspective, the big news this week, actually on Tuesday, was the OFCCP released its corporate scheduling announcement list, which is its annual list of contractors and subcontractors who've been targeted for potential compliance evaluation. Interesting thing is 2019 was the first year that they've only released it electronically and are not sending the traditional paper letters to facilities that have been selected. In 2019, OFCCP listed 3,500 companies and individual establishments that they've identified for audit. This is, over 2 times the number that they had in 2018 through from both their original list and then their mid-year supplement, and over 4 times as many as the OFCCP listed back in 2017. So it's kind of surprising, given in the current administration, is that OFCCP is actually ramping up their enforcement mechanisms in the government contracting arena. They do this through a number of different ways. The most traditional is the desk audit or establishment review, where the OFCCP will send you a list of 22 categories of different documents and information related to compliance with all 3 laws. And they actually require you to submit your current year written affirmative action plan, hire termination applicant and promotion data from the prior year. And if you get audited at least 6 months into the current year, you have to submit this type of data for that first 6 months of the year. So January 1 through June 30th. You need to submit documentation evidence of your outreach and recruitment efforts. And then a big one that was added a couple years ago is employee level compensation data. Now, in August of 2018, the OFCCP released a directive, outlining their new emphasis on compensation analyses and preventing compensation discrimination. And they're really ramping up how they're looking at compensation data, where they're actually now running regression analyses on this employee level data. I'm actually currently handling an audit for a client in Ohio where OFCCP made this specific request for us to group their 1,500 employees into, as they call, pay analysis groupings, because they wanted to run regression analyses to see if there's any sort of discrimination or potential discrimination in compensation. So when you get this letter, you have 30 days to submit all this requested information to OFCCP. Then they review and may seek additional information, conduct compensation or other types of interviews, or initiate other compliance steps, which the next step would be an on-site audit, where an OFCCP team actually physically comes on site to your location and spends several days, usually 1, 2, or 3, depending on the audit and the size of the location. And during an on-site visit, they typically conduct a physical facility tour and review, where they're looking for, do you have your postings in the right place? Do you have the correct number of handicap parking spaces, stuff like that. They like to conduct interviews with managers, supervisors, and other employees. The important thing to remember here is if it's a manager or a supervisor, you're allowed to have an employee representative sit in during the interviews. If it's a non-supervisory employee, you as the employer are not allowed to have anybody sit in on that interview. So you really don't know what the OFCCP may be asking your employees. During an onsite, they may look at additional documentation, and then they hold conferences both at the beginning and at the end with employer representatives. And this can occur, an onsite can occur as an initial step of an audit, but it's typically a follow-up to a desk audit. It may signal their interest in potential areas of discrimination. Some of the new enforcement efforts in 2019, first are compliance checks. This was implemented last August by the OFCCP. And what they would do here is that they would conduct a compliance check requiring certain contractors to submit evidence of placement goals progress and outreach and recruitment efforts. In 2019, they've identified 500 contractors of the 3,500 for a compliance check. Actually, their future plan is to require annual verification or certification from contractors on AAP compliance. This is similar to what you see with a number of state governments. If you have a contract with the state, they tend to require you to submit annual verifications of your compliance. So this is something to look for down the road from the OFCCP. The other big, and this is what a letter would look like in a compliance check. So for the current year, they're going to ask for documentation of your AAP results from the prior year, job advertisement samples, and including listings with state employment agencies, and examples of reasonable accommodations for disabilities that you've provided. The other new development are what they're calling focused reviews. This is really a mini desk or on-site audit focusing on your compliance with one particular law. This was also implemented last year, and this is a process where the OFCCP will eventually come on-site and conduct a comprehensive review of a particular authority. Again, they listed 500 contractors on their 2019 list who are going to be subject to focused reviews, and they actually received approval for a specific scheduling letter where they're going to look at Section 503 compliance this year. And here's what that letter looks like, where instead of 22 data points, they're asking for 12. And the other thing to remember is they automatically come on site during a focused review. And OFCCP has indicated these on-site visits will occur after September 1st of 2019. And for this year, they're actually targeting corporate headquarters of companies that they have on the list. So they actually come on site to your corporate headquarters and look at your Section 503 compliance. Outside of OFCCP, from the wage and hour perspective, you have to worry about the wage and hour division. As an employer, you're generally subject to the Fair Labor Standards Act. If you have a service contract, the wage and hour division also has authority to enforce SCA compliance. And this audit typically involves an investigator coming on site where they look at relevant records for a 2 to 3 year period, including payroll documents, employee rosters of individuals who worked on the covered contract, and even contract and award documentation. The important thing to remember here is outside of wage and hour division, requests for these documents can also come from the contracting agency, as Ray mentioned earlier. During an audit, wage and hour division will also interview employees working on the covered contract, and they'll again conduct a facility tour. At the end, they actually hold a final conference with your representatives to identify potential violations, discuss appropriate remedies, usually involving you paying money to the government, and disclosing whether or not they consider Service Contract Act debarment criteria to have been met. So the Service Contract Act does authorize debarment of contractors for violations of the prevailing wage and fringe benefit requirements. It's typically reserved for pretty egregious cases of noncompliance, but it is something that's within the investigators' arsenal when they come on site. And at the end of the visit, they'll prepare a written report and recommended actions, and the division will either seek a settlement of any violations or an enforcement action before a federal administrative law judge. So, in terms of, what are the potential consequences here? We've already mentioned most of these, but there are really a number of different weapons at the government's disposal. We talked about the withholding of progress payments, cancellation, and debarment, but OFCCP and Wage and Hour Division also love to enter into conciliation settlement agreements, where a contractor has to agree to either pay some money or take affirmative steps and are subject to progress reporting to the government. They can seek enforcement actions before an administrative law judge. There can be affirmative hiring requirements, as well as payment of back wages and benefits. From the OFCCP's perspective, in fiscal year of 2018, they actually entered into 47 separate conciliation agreements with contractors and subcontractors for a variety of violations, both technical violations, so these are record keeping, AAP compliance, not having affirmative action plans in place, as well as financial violations where there was actually evidence of discrimination or compensation disparities. So far in 2019, they've entered into 24 of these agreements, 9 of which involved financial penalties, and so far they've imposed over $6 million in back pay or financial penalties for violations of employment-related requirements. From the Wage and Hour Division in fiscal year 2017, they investigated 549 cases involving violations of the Service Contract Act. They found over 20,000 violations, and a total of almost $32 million in back wages or benefits were paid to almost 13,000 employees. In 2018, that number went up. They looked at 609 cases. There were over 28,000 violations, and a total of over $40 million in wages and benefits were paid to almost 17,500 employees. So it's definitely, from the Wage and Hour Division and OFCCP, they're very active in their enforcement. So it does highlight the importance of complying with all the various employment-related requirements that go along with doing business with the government. So I know we went a few minutes over. I wanted to leave open if there is any questions at this point. Please feel free to enter them into your box. Otherwise, feel free to reach out to Ray or myself directly. But if there aren't any questions, I would like to thank you for joining us today. I do apologize for running a few minutes over. I wanted to let you know that our next session will be on May 30th as part 2 of this 5-part series. We'll be talking about pay equity audits, what they are, why are they important, how do you do it? And again, if you have any questions, please don't hesitate to contact either myself or Ray McCann. So we'd like to thank you for attending today, and I hope everyone has a wonderful day.